Good afternoon and welcome to the Shenkman Wealth Management Accountant Attorney Summer Webinar Series. This program is entitled The Impact of Divorce on Estate Planning and Wealth Management. For those who don't know me, my name is Jonathan Shenkman. I'm the president of Shenkman Wealth Management. In that role, I work as a financial advisor, portfolio manager, and a fiduciary for my clients to help them achieve their financial goals. The goal of all my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in Barron's, CNBC, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. After the program, I'll send out a link to all the publications where I publish my work. One quick note before I introduce our esteemed speakers, which is the handout to this program was sent out within the reminder email yesterday morning and this morning as well. It will also be sent out again in the follow-up email to this program tomorrow morning. Today, we're privileged to hear from Nicole Kobis and Elizabeth Candido Petite, both partners at New Jersey-based law firm Lindabury, McCormick, Estabrook, and Cooper. Nicole is a partner in the firm's divorce and family law group, where she works tirelessly with her clients as they navigate the challenges of divorce. She advises clients on matters involving divorce, custody, spousal support, child support, equitable distribution, and domestic violence. She's experienced in negotiating and drafting marital settlement agreements for use in uncontested divorce matters. Nicole is well versed in drafting complex pre- and post-judgment motions. She also helps clients prior to their marriages in drafting or reviewing prenuptial agreements. Nicole is accredited New Jersey family divorce mediator and is skilled at working with divorcing parties so they achieve amicable resolutions. She's also trained in collaborative law. Elizabeth is partner in the firm's wills, trust, and estate group, where she concentrates her practice in areas of estate planning and the administration of trusts and estates. She works with individuals, families, corporate fiduciaries, and with other professionals such as financial advisors and accountants to create and implement a customized estate plan. Elizabeth prepares all types of estate planning documents to meet her clients' needs, including wills, revocable and irrevocable trust, durable powers of attorney, and advanced directives for healthcare. She has experience creating and funding family limited liability companies and other corporate structures to transfer personal wealth and family businesses to the next generation. Today, Nicole and Elizabeth will be speaking on the impact of divorce on estate planning and wealth management. Before turning the program over to Nicole and Elizabeth, just a heads up that this program is approximately 45 minutes in length. The first 30 minutes or so will be a presentation, and that will be followed by about 15 minutes of pre-submitted Q&A. And with that introduction, I'll now turn the program over to Nicole and Elizabeth.
Jonathan, thanks so much for the introduction. Thank you so much for having us here. I know on behalf of Elizabeth and I, we are thrilled to be able to speak to you today on something that touches both of our practice areas and something that we really enjoy collaborating on. So thank you again. So like Jonathan said, there are a lot of considerations when it comes to divorce, planning for marriages, planning for protecting assets, both personally or with your family. So without further ado, let's get into it. Family asset considerations. So family structures are different in terms of how people have arranged their assets, whether or not it's grandparents passing down funds to grandchildren, whether it's children protecting their own assets. And there's a lot of considerations that go into it when you have changing family structures. So the most popular way for you to deal with protecting your assets is a prenuptial agreement. I'm sure everyone has heard of them, and I'm sure that a lot of people have a lot of preconceived notions about what goes into them and what they're used for. So very basic, a prenuptial agreement, it's an agreement entered into between two individuals prior to marriage. It takes effect on the date of the marriage. So if the parties don't marry, the agreement is null and void. Who needs a prenuptial agreement? Now, most people have this preconceived notion that unless you are extremely wealthy or coming into a large sum of money, those are the only people that need a prenuptial agreement. It's not the case. Anyone can get a prenuptial agreement. Prenuptial agreements take into account a lot of different topics, and they're not just for the rich and famous. They are for the everyday individuals who are seeking to get married. However, there's a few special areas where prenuptial agreements become very important. Second marriages, especially if there's children involved from first marriages or support obligations that are being paid through a first marriage, marriages with children from previous relationships, protecting assets that you'd want those children to get, not only those children, but also the children of a forthcoming marriage. Individuals with largely different earning capabilities. Prenuptial agreements take into account not only what is happening today as you enter a marriage, but also what can happen in the future. Individuals with anticipated inheritance. This is a large reason why many people get prenuptial agreements. It is definitely much more of a larger family conversation, because typically it's involving conversations with parents, grandparents, aunts, uncles, things like that. And yes, even if you don't have a prenuptial agreement, there are ways to protect inheritances. However, prenuptial agreements make it much more secure in terms of your ability to secure those assets for your loved ones. Individuals with ownership in closely held businesses. A lot of times it can get very sticky in marriages and divorces when there's family businesses on one side of the ledger. So it's always something that you want to be able to tightly deal with in a prenuptial agreement. Timing of prenuptial agreements is crucial. So, like I said before, it's before you get married, a prenuptial agreement must be in place. However, the closer you get to a wedding date, the more suspect they become. There's people tell stories of waiting for a bride to walk down the aisle because they're signing a prenuptial agreement on the day of the wedding. You don't want to be in that kind of situation, and you don't want to have any kind of inference of duress, coercion, or you're getting pushed up against the wall right before a wedding date in order to enter into this agreement. It should be something that is done for as far out as possible so that everyone has the ability to review the agreement and have full financial disclosure before entering into the agreement. In New Jersey specifically, a prenuptial agreement is the only way that you are able to disinherit a spouse. This is crucial a lot of times, especially in second marriages, where you want to preserve your assets for the children of a first marriage, and just something to consider. What goes into a prenuptial agreement? A lot of people come into my office and they're like, well, I just don't want to pay alimony, and anything that I come into the marriage is mine. Anything that they come into the marriage with is theirs. I'm like, okay, great. And then I have like a laundry list of other things that I need to ask them about that most people are very shocked to hear go into a prenuptial agreement. So things that are addressed: spousal support, also known as alimony; equitable distribution, that means dividing assets. So we're talking about businesses, stocks, investments, bank accounts, property, both real and personal. How we're going to treat inherited assets, and how we're going to treat assets in someone's estate. All of those things go into a prenuptial agreement. Very important though, child support and child-related issues are not addressed in prenuptial agreements. They absolutely cannot be. So if you want to try to do anything related to a child in a prenuptial agreement, that's not going to work. The requirements for a prenuptial agreement: full disclosure of assets. So at the back of any prenuptial agreement, you will see an asset schedule that will list not only all the accounts that someone has and all the property they have, but it'll also list an estimated value to the best of your capability as of the date of entering into the agreement. You want the opportunity to review it with independent counsel. Personally, I will not do a prenuptial agreement that does not have two attorneys in it. I think it is just not the wisest way to practice. I think it is crucial that each party goes into it with full independent legal counsel. And in fact, I will encourage, if I am representing the proponent of the prenuptial agreement, I will encourage them, if it's a money issue, for them to pay for their soon-to-be spouse to have an attorney, because I just think the more secure you can make this agreement, the better off that you're going to be in the end. And last but certainly not least, that the agreement was entered into voluntarily. And that goes back to the timing of it, and also about not wanting to feel forced, and making sure that you understand your rights when you're entering into not only a prenuptial agreement, but any agreement in general.
So thanks, Nicole. One of the things that Nicole had mentioned before is that there are other ways to protect assets besides prenups, and one of those is trusts. A lot of times this is where the other family members will get involved, as opposed to, you know, the bride and groom who are entering the marriage. Parents, other family members, for example, grandchildren, or sorry, grandparents are the most likely ones who would undertake making a trust for their children. Sometimes this happens when the kids are very little. Sometimes this happens as they get older. Rarely, but every once in a while, it'll happen sort of in lieu of a prenup, meaning like, you know, your daughter has gotten engaged and now you're getting worried because maybe, you know, you're starting to think about these issues that what if they get divorced? Is the spouse going to take everything? But usually these are sort of well thought out, like family wealth vehicles to protect assets that you want to pass along to your children, their children, future generations. So basically, the trust has to be irrevocable, meaning that it cannot easily or cannot at all be changed, because that's a key factor in making sure that the assets cannot get passed along to a creditor, or in a divorce, the divorcing spouse is considered the creditor in this case. This is basically a creditor protection trust for your children. We're talking about spouses. It also protects them from, they get into a car accident and someone sues them. Any type of creditor is sort of the object of what you're trying to protect in this kind of trust. Anyway, so the trust should provide that the assets are distributed based on the trustee's discretion, right? If the trust says that distributions must be done quarterly or any sort of interval of that sort, then whatever has to be distributed, once it's distributed, will be touched by the creditors, the divorcing spouse, the lawsuit, whatever the case may be. So you want to give the trustee as much discretion over when to make or to not make a distribution, income and principal, but generally speaking, principal is the larger bucket. The trust should also be drafted so that it's a spendthrift trust, which means that creditors cannot sort of reach into the trust and grab assets that are in the trust, even if they have not been distributed. So spendthrift trust in New York and New Jersey are addressed in the statutes. New York says all trusts are presumed to be spendthrift trusts. So you don't even have to do anything special or different. You just make a trust and it's automatically a spendthrift trust. New Jersey, it's essentially the same, although the trust should mention the words spendthrift trust in it. That's literally all it has to say. This trust is a spendthrift trust, period. You don't have to go into anything more than that. So it's very easy to sort of add this protection. Who should serve as trustee? This is really important because you want to make sure that the beneficiary, meaning the person the trust is set up for, in this case, probably like your child or your grandchild, is not a trustee, because you don't want that person to be the one deciding when assets get distributed, because then, for example, in a divorce, the divorcing spouse could say, well, my spouse has the authority to make a distribution, so force him to make a distribution to me and I can get money from the trust. You don't want that to ever come into play. In New Jersey, the beneficiary can be the sole trustee, or it can be a co-trustee, and the trust can still be considered a spendthrift trust. So it's possible to include the beneficiary. However, that's not the best practices. I would stay away from that unless there's really no other option to name the trustee at all, the beneficiary as the trustee. Other things to keep in mind, as Nicole said, trusts are only one aspect of it. It doesn't solve all the problems, because once the assets have been distributed to the beneficiary, they're fair game. The divorcing spouse, the car accident creditor, whoever, they can attach to them just as the same way that they could attach to this person's other assets. Public policy may also come into play here. In terms of alimony or child support getting paid from the assets of the trust. And that's especially true if the family has been using assets from the trust to cover things such as their basic living expenses, things for children, etc., as opposed to just sort of having the trust, on the side and maybe dipped into for like very special and unique reasons. Some states are attacking trusts in divorce proceedings. There's a pretty recent matter that came out of Massachusetts that basically allowed the parties to dip into the trust to take some of the spouse's share of marital assets. You might be saying, well, I don't have any clients in Massachusetts, who cares? But, these are the kind of things that once one state starts doing it, maybe other states will follow. Or you have a client who lives in New Jersey or New York, and maybe all their kids live here now. They create trust. 5 years from now, one of their children moves to Boston. Now that trust might be governed by Massachusetts law at some point. So it's always a good idea to keep these things in the back of your mind, even if they may not apply to any certain situation right now. So now, once you have trust set up, perhaps, and a prenup drafted, maybe, sometimes things don't go as planned and divorce happens.
So some pre-divorce planning. So no one gets married thinking that they're going to get divorced. Everyone gets married thinking that their marriages are going to last forever. And unfortunately, life takes sometimes different paths and people grow apart, things happen, and a divorce ends up being the road that you want to take. So when you are about to enter into a divorce, the first and foremost thing that I need clients to understand always is that if you're getting divorced, it is going to mean that you have to tighten your budget. There is one pot of money that used to support one household. That one pot of money is now going to be divided into two and have to support two different households. Whether your annual income is $100,000 or whether it's $100 million, it is going to mean in some fashion that your budget needs to be restructured. So in order to kind of grasp that concept and to wrap someone's head around that, you always want to try to gather as much financial information as possible. You know, when I have a client that comes into my office, I would love for them to have, you know, a nice binder with their paychecks and their W-2s and their tax returns and their stock and their investment accounts. That's not reality, but the more information you can get, the more you'll be able to make an educated decision about what steps you want to take. So tax returns, paychecks, monthly bills, a lot of people don't even know what their monthly bills are. You know, they've set their accounts up on auto pay or their spouse may have set them up and they've literally never even paid a mortgage payment. And I hate to say that that is uncommon, but it's certainly more common than not in my office. And so trying to get people to understand where their money is going and how it's being spent is crucial when you're entering into this phase of transitioning your family. In some states, really most states, there is some form of this document. It's called, in New Jersey, it's called a case information statement, but it gives you a full financial picture of every single asset and liability a couple has. So real property, personal property, account statements, debts, liabilities, absolutely everything that they have. So it paints a picture and you file it with the court so that a court also understands exactly the assets that are at play in a given case. So ideally, you'd be able to get through a divorce process, move on as former spouses, and then start the next chapter of your lives. But sometimes, unfortunately, that doesn't work that way. And divorce can take a really long time, especially with COVID and the slowdown in the court systems. It's definitely taking longer than not these days. So what happens if, unfortunately, your spouse dies during a divorce? Changing a beneficiary once a divorce has started is very, very difficult, if not impossible to do, and something that you shouldn't do, even if you're able to do it. So if you are still married and you're going through a divorce, before a judgment of divorce is entered, you're technically still married in the eyes of the government, right? But you then kind of enter into this not completely black and white territory anymore about what would happen then if someone passes away. Do they get a right of an elective share? Do they get equitable distribution? Do they get some kind of something in between those two? It's kind of a black hole of the court having to equitably determine what is fair, recognizing that if the spouse had survived for another year or two, they would have been an ex-spouse, not a current spouse, and how to balance those interests.
Yeah. Thanks, Nicole.
Yep.
The law prohibits you from disinheriting your spouses. So as Nicole was saying, until the divorce is final, the parties are technically still married. If one spouse dies, the other is still the surviving spouse. In community property states, there are only 9 of those, and they're listed here on this slide. The surviving spouse automatically would receive 1/2 of the property, and all assets that are acquired during marriage is considered community property. So, in a normal situation where you're not talking about divorce, just one spouse dies, the survivor would automatically get half. In the common law states, which is all the rest, which is New York, New Jersey, Connecticut, all the states in this sort of part of the country, the surviving spouse has what's known as the right of election or elective share. They can elect against the will if they are not already a beneficiary, or if they are a beneficiary, but they're not given enough. So New York says that the surviving spouse has to receive the greater of $50,000 or a third of the estate. New Jersey, it's a third of the augmented estate, and that brings in some non-probate assets, for example, a retirement account or a life insurance policy. And New York sort of does the same. So it's always a little bit of a complicated calculation when you're trying to take a look at what all the assets are, what's included, what's not included, how do you divide it, et cetera. For New Jersey, augmented estate also may include some assets that are only in the surviving spouse's name. So that's kind of the difference between New York and New Jersey. The right of election must actually be elected. It's not automatic like it is in community property states. And you have a certain time period, and the surviving spouse has a certain time period in which to make that election after the one spouse passes away. This can be waived, and often it is waived in a prenup. The spouses will say, we are not going to elect against each other's estates. And that's one way, probably the best way, to make sure that your assets are going to be your assets and pass along to your children from a prior marriage, if you have one, after you pass away. So all of this goes to sort of Nicole's point of there is a gray area of what happens during the divorce if one spouse passes away. This is one avenue that you might be looking at. Equitable distribution is sort of the counterpart of in the divorce proceeding. The assets have to be divided somehow. Just because you die doesn't mean you're out of luck. Your estate does not lose everything. Can you execute a will while you're getting divorced? The answer is yes, you can. What you can and cannot put in the will is sometimes a little bit trickier based on, the fact that you are going through a divorce. As we said, you might have to include some sort of some part of your assets for your spouse, whether you want to or not. But there's other things that should be looked at, and which is why it's a good idea to at least think about whether you want to do a will. You're still married, so if you did not have a will, your spouse or the survivor would technically be entitled to serve as the administrator of your estate. And that means they would be the ones tasked with gathering all your assets, making distributions, paying creditors, going through your personal belongings. You do not have to do that. You can name whoever you want as executor, but you have to have a will to have an executor. So that's a big reason why, even if that's the only change you make, you leave your spouse as a beneficiary, but maybe now you appoint your sibling as executor, or your parent or an adult child, as opposed to your spouse. So it's not your almost former spouse doing these things on your behalf. And as I said, you don't have to name your spouse as your executor. You also don't have to name your spouse as your power of attorney or medical proxy. Those are documents that would take effect right now during your lifetime. If you became financially unable to manage your property or unable to make medical decisions for yourself. And if you had documents done prior to the divorce, you've probably named that spouse or ex-spouse as those positions. So that's another reason why taking a look at your estate planning documents during divorce is going, while the divorce is going on, might be a good idea to rename some of these positions to other people.
So Elizabeth spoke a lot about probate assets and things that go through an estate, but what about non-probate assets, changing beneficiaries on those? So a perfect example of the non-probate asset would be a life insurance policy. That's where it comes up a lot. Can you change your beneficiary on non-probate assets once a divorce is filed? Short answer is no. Obviously, there's always asterisks after any kind of yes or no answer that any attorney gives, but traditionally the answer is no. And some states even go further, and there is a look back provision. So if on January 1st you're contemplating, divorcing your spouse, but you don't get around to filing a complaint for divorce until April, but you change your life insurance policy before then, the courts would be well within their right to direct you to change your life insurance policy back to your soon-to-be former spouse. In New Jersey, for example, there's also a form that you have to fill out as a litigant. It's a certification, meaning it's signed under oath, that lists every single insurance policy that's currently in place. So your health insurance, life insurance, homeowners insurance, renters insurance, car insurance, disability insurance. Not only the existence of the policy information, the amount of the benefits to be paid, and who the beneficiary of those policies are. You file that along with your complaint for divorce. So if there are any changes that are made to that, you have an obligation to continue to update that as the divorce goes on. In addition to, if there are any changes that have been made, and then unfortunately, if someone passes away, then it's just going to result in litigation, because then ultimately the person who thought that they were supposed to get that money is going to sue the person who in theory is going to get that money. And then there'll be a debate as to who is actually entitled to what money. So it's just not a good idea to try to start fooling around with beneficiary changes once a divorce is filed.
Okay, so now you are divorced. The divorce is final. What can or should you do in terms of assets with beneficiaries on them and your other estate planning documents? All right, if you do not make any beneficiary changes, the judgment of divorce and the settlement agreement, however, the divorce goes down, will automatically change. I'm sorry, they do not automatically change them. In certain aspects. So for example, just because you got divorced, that does not automatically wipe your spouse's name off of your retirement benefits. The financial institutions are bound by whatever the beneficiary designation is on file at the time of your death. So that's why Nicole was saying, fights can sometimes ensue. Sometimes fights ensue even when there is no divorce in the picture, just between, a second spouse and children from the first marriage. If if it's not what the family thought it was going to be, for example, the financial institutions have to go with whatever the beneficiary designation says. A client can change estate planning documents to eliminate the ex-spouse wherever the ex-spouse is mentioned. And that is generally a very good idea. Sometimes it is very hard, admittedly, to get clients to do that because they have just spent probably a lot of money and a lot of emotional energy on this divorce. And now the last thing they want to hear is, please go see your estate planning attorney to update all these documents because they're not good anymore. They don't want to do that, but it's really, really important that you do it. Your ex-spouse should not be anywhere in your documents once you are divorced. You also don't have to worry about any sort of right of election issues anymore because this person is not your spouse. So good news is that there are some things that are automatically changed after the divorce is final. For example, if you don't update your will and your will says, I leave all my property to my spouse, and that person is no longer your spouse, that would be null and void if you were to pass away. You'd look to the next person in line. If it said first my spouse, then my kids, your kids would automatically get it. So that's the good news. Again, if you named your spouse as the executor of your will after the divorce, that person would no longer be entitled to serve as the executor. And same would be true for if you have power of attorney and named your spouse as the agent under that power of attorney. Right of survivorship of jointly owned assets is also something that gets severed with the divorce. If you have a joint account, let's say, a checking or a savings account at the bank that names, husband and wife as joint tenants with rights of survivorship, the divorce changes that ownership to be tenants in common. So you would each have one half of the account, as opposed to if one of you died, that the survivor would be entitled to the entire account. However, again, one reason to take a look and to change your documents, this default rule to sort of eliminate your spouse, in some states that only applies to the spouse and not their family member. So it's pretty common actually in estate planning documents for some people to name their fathers-in-law, their brothers-in-law, sister-in-law, whatever, as a fiduciary position. I have a lot of clients that'll say, okay, well, if my spouse can't do it, then, name his father as the backup executor because they have a close relationship. Maybe this person's family is far away and the spouse's family is nearby. There's a New York case from about 7 or 8 years ago that dealt with this exact issue, that it was father-in-law named as successor executor, and they're trying to argue that, you know, they got divorced, so the father-in-law shouldn't be entitled to serve. And the court said, no, the law does not extend to anyone past the spouse. So the father-in-law still had the right to serve as executor of his ex-daughter-in-laws or ex-son-in-laws, I forget which one it was, estate, even though, you know, the will that named the spouse as the first person, you know, that designation was no longer valid. So it's a really good idea to update all of your documents. It is worth the time and the money, even if you have already spent what seems like a lot of money to do it, because these are, you know, real life issues that you want to make sure are addressed. This is your financial security. This is your, you know, your family's financial security. And it's important to, you know, take a look at that and make sure that everything is up to date. It expresses your wishes, and you're not leaving your children, your siblings, your other family members with a huge mess, for lack of a better word, to deal with after you pass away. All right, Jonathan, I think we're going to open the floor to you for some questions if you have any for us.
Yeah, absolutely. Thank you so much, Nicole and Elizabeth. We'll jump into the questions now. The first one's for Nicole. Do you recommend that a matrimonial lawyer or a trust and estates lawyer prepare a prenuptial agreement?
I absolutely recommend it should be a matrimonial lawyer. And Elizabeth and I actually have talked extensively about this, and Elizabeth happens to agree. So the reason for why I say this is because if a matrimonial lawyer is addressing and drafting a prenup, we're looking at it from a lens of what is going to prevent future family post-divorce litigation. That is like our lens, as opposed to necessarily more of the protection lens. We're looking for what is going to prevent a problem down the road. You can definitely know, when I get a prenuptial agreement in, I can tell whether or not it's drafted by a family law attorney or a trust and estate attorney. And I think it's just a smarter route to go to a family law attorney, because they're more well-versed in all the other issues that need to be considered from the family court context rather than the trust and estate context.
Yeah, I would agree with that. That's one area that I do not touch in my practice. I know a lot of trust and estates attorneys do draft prenups, but as Nicole said, it's important to you know, this is only going to really come into question if there is a divorce at some point. So it's really good to draft it from the start, knowing, you know, what issues need to be addressed in that document.
Okay. Elizabeth, what can a trust beneficiary do to protect his or her interest in the trust from being subject to equitable distribution in a divorce proceeding?
So the best thing to do, honestly, is to only take distributions from that trust, or you know, to have the trustee distribute to you assets that you need and that you're going to use. You don't want to just, you know, compile trust distributions and just hold on to them, because then they're there, right? A lot of times people take distributions from a trust and deposit it into a joint account with their spouse. Well, you've now destroyed the, you know, the sole nature of that money as yours. You know, you've commingled it with your spouse, and if you entered into a divorce, that would just be part of the regular joint account that got divided among you. So my recommendation would be, if you have a trust, you know, take distributions from it sparingly, take it for a specific purpose and use that money right away. Or if you are going to sort of like hold on to it for yourself, open up an individual account that does not have your spouse's name on it and invest that money or do whatever you want with it separately from any marital assets.
It looks like the next one that came in could be there for Nicole or Elizabeth. What should someone who's contemplating a divorce do if he or she expects to receive a significant gift or inheritance from a parent?
So, I mean, Elizabeth, I'll start. At least if you don't want to take any additional legal steps in terms of trying to more securely protect that inheritance, at the very least, you should open up a separate account with just your name on it, put the entirety of that money into that account, save every single document, whether it's the will, whether it's the check, whether it's the life insurance check, whatever it is that's going to come along with that money, to tie it back to the reason why you're getting it, and leave it in that account by itself. And that will be at least some level of protection for you. Obviously, the difficulty that comes into play is then kind of what Elizabeth was alluding to before, is that now all of a sudden you and your spouse want to buy a beach house and you're like, oh, remember when grandma left you that $100,000? Can we use that as a down payment? Now you've bought a beach house with it. You're never seeing that $100,000 ever again, because now it's going to be marital property. Like, those are the things that in commonplace, that's what people just do. And they don't think about the ramifications down the road without additional legal protections.
Right. Now, if you have a little more time and this inheritance is sort of coming your way, you might be able to talk to the person. You know, let's say it's your parent who has terminal cancer and you know that they're going to pass away soon, and your marriage is on the rocks, and you're like, Mom, I really don't want any money from you that's then going to get passed along to my, you know, maybe ex-spouse in a few years. Talk to that person about taking you out as the beneficiary. You know, why don't you change your will, Mom, and instead of naming me as beneficiary, have it go directly to the kids, or you know, maybe give it all to my sibling. I don't need this money anyway, and it's not even going to end up in my pocket. It's going to go to this woman who I hate, you know, or whatever the case may be. So there may be some planning opportunities that you could encourage the person who's going to leave you the money to do in order to avoid this issue as well.
Looks like the next one's for Nicole. In the divorce disclosure process, do you have to disclose assets that you have a discretionary interest in?
Yes and no. So it depends what the interest is. If you know that something is coming to you, so let's say you're the beneficiary of a trust and you know that upon your 21st birthday, you're going to come into something, and then in your 25th birthday, you're going to come into something else, and your 30th birthday, something else. Those things you would have to disclose. But if you think grandma has named you as the beneficiary of her life insurance policy, things like that you don't have to disclose, because those can be changed at any point in time. So it's only things that you are guaranteed to get without necessarily the ability for someone to change it, or a condition beyond like an age restriction being met, because if that condition never is met, then you never get that money.
Right. Just to sort of piggyback off that, you know, just because you're getting divorced and you can't change certain things of your own, that doesn't mean that no one else can. You know, if you're in a divorce, your mother certainly can change her beneficiaries even after your divorce has been filed, to take you off as a beneficiary. You know, those things can be changed up until the date of that person's death, and you technically have no control over it.
It looks like the final question we have is for Elizabeth. When a couple gets divorced, is the same firm able to represent one or both of the individuals if they already represented the couple for estate planning?
The short answer is no, they should not. This is an ethics question, and you know, as Nicole said, whenever you say yes or no, there's always an asterisk. So generally speaking, you know, the couple, they came in, they did estate planning together. This is really common. So the firm had a relationship with both of the spouses. Now, if one of them comes back to you and says, you know, I need to get divorced, can you represent me? Well, your almost former spouse, you know, the other side of this divorce, is a client or maybe a former client of the firm. The conflict rules, the rules of professional responsibility, ethics, I forget what it's called, Nicole. What's the actual? The conduct, thank you. Say that you need a waiver, you need the consent from a former or a current client to represent, to be adverse to them, right? And chances are most of the spouses are not going to do that, because your firm has some, you know, very personal information about you. So why would you allow that firm to use it against you? Now, that being said, there are always some cases where, you know, let's say the firm represents a family going back many generations, and then they did estate planning for, you know, one of the kids, and now that child's getting divorced. You know, there might be the argument that this is the firm, the family's firm, and we've always represented the family, and it was not a one-off per se that we did estate planning for this couple, but, you know, it really wasn't that involved. And that might be a case where it might be possible for the firm to represent one side of the couple. But yeah, that's one of those issues where it's like, you don't even really ever want it to become an issue. Stay away from it. There are a lot of other attorneys out there. We know other attorneys. We're happy to make that referral. You know, it's better. It's for everyone's best interest to sort of have fresh eyes in those situations.
Great. Okay, well, thank you so much, both Nicole and Elizabeth. Naturally, if anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Nicole, Elizabeth, or myself where appropriate. And I'll be sure to include their contact information in the follow-up email to this program. As I mentioned at the onset, the goal of these programs stay up to date on timely wealth management related topics and to collaborate where appropriate. I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. 3 more quick items before I let you go. First, my summer webinar series continues on June 28th with my program entitled Timely Estate Planning Strategies for Private Equity and Hedge Fund Executives, featuring Kevin Matz, partner at Aaron Fox Schiff, based in New York. And I'll send out an email in the coming days with registration information. Second, please take 30 seconds to fill out my survey at the end of this program. It helps me improve my webinars and provide timely and interesting content to attendees. And I thank you in advance for that. And finally, if you'd like to be kept abreast of my latest articles, webinars, and all the other work I put out, you can sign up for my free monthly newsletter. Simply email me with the word newsletter in the subject line. And with that, this concludes today's session. Please stay safe and healthy and have a wonderful day, everybody.